Practice areas. Disclaimer. This legal news roundup is provided for informational purposes only and does not constitute legal advice. The information presented reflects developments as of May 7, 2026, based on publicly available sources including courthousenews.com, abajournal.com, politico.com, ftc.gov, and other legal publications. Readers should consult qualified legal counsel for specific legal matters. The inclusion of any case, ruling, or development does not constitute an endorsement or legal opinion. Laws and regulations are subject to change, and court decisions may be appealed or modified. This document is intended for legal professionals and stakeholders seeking to stay informed about major legal trends across multiple practice areas. Supreme Court ruling Royals election law and courts independence. The Supreme Court delivered a seismic decision on April 29, 2026, striking down Louisiana's congressional map that included two majority black districts in Louisiana v. Calais. The 6-3 ruling, authored by Justice Samuel Alito, fundamentally weakened Section 2 of the Voting Rights Act by requiring plaintiffs to prove intentional racial discrimination rather than merely showing discriminatory effects. 24. Justice Elena Kagan, in a powerful dissent joined by Justices Sotomayor and Jackson, warned the decision renders Section 2 all but a dead letter. 25. The decision triggered immediate chaos in Louisiana, where Governor Jeff Landry suspended congressional primaries just days before early voting was scheduled to begin. 26. On May 4, 2026, the court took the extraordinary step of immediately putting its ruling into effect, bypassing the normal 32-day waiting period. This expedited action sparked a bitter exchange between Justice Alito and Justice Ketanji Brown Jackson, with Alito calling Jackson's dissent baseless and insulting for suggesting the majority was showing political bias. Jackson accused the majority of unshackling itself from procedural constraints to influence the implementation of its ruling. 27. The Louisiana map saga began in 2022 when the state initially drew a map with only one majority black district despite black residents comprising approximately 30% of the state's population. After litigation forced Louisiana to create a second majority black district in 2024, a group of non-African American voters challenged the new map as unconstitutional racial gerrymandering. 28. The Supreme Court's ruling now allows Louisiana's Republican-controlled legislature to redraw the map before the 2026 midterms, potentially giving the GOP an additional House seat. 26. Civil rights advocates expressed alarm at the decision's broader implications. The ruling applies not only to congressional districts but to all electoral maps nationwide, including state legislatures, city councils, and local bodies. 29. Mississippi Governor Tate Reeves announced plans to call a special session to redraw his state's maps following the ruling. 30. The decision marks the culmination of what Justice Kagan described as a decades-long project by the conservative majority to dismantle the Voting Rights Act. 8. Since the court's 2013 decision in Shelby County v. Holder gutted the act's pre-clearance provisions, Section 2 had remained as the primary tool for challenging racially discriminatory voting maps. Now, by requiring proof of intentional discrimination, a standard that Justice Kagan noted as nearly impossible to meet since officials can easily offer race-neutral justifications, the court has effectively eliminated this protection as well. 25. Immigration law crackdown and court battles. The Trump administration's expanded immigration detention policies have triggered an unprecedented wave of legal challenges, with more than 18,000 habeas corpus petitions filed in federal courts in early 2026, more than under the last three administrations combined. Texas and California account for approximately 40% of these cases, with immigrants filing an average of 200 habeas petitions daily nationwide. 24. The surge stems from a July 2025 ICE policy shift that reinterpreted existing law to require mandatory detention for most immigrants arrested in the interior, even those with decades of U.S. residence, family ties, and no criminal history. Under the new interpretation, anyone who entered without inspection is treated as an applicant for admission, subject to mandatory detention under 8 U.S.C. 1225(b), rather than discretionary detention under 1226(a), which allows bond hearings. 25. This policy shift has created a stark geographic divide in immigration law. On February 6, 2026, a three-judge panel of the Fifth Circuit Court of Appeals upheld the administration's detention policy in a 2-1 decision, making the ruling binding on all federal district courts in Texas, Louisiana, and Mississippi. 26. Yet despite this appellate precedent, some Texas federal judges have found workarounds, ruling that immigrants with established U.S. ties possess a constitutional liberty interest that cannot be taken away without due process, a separate ground for release that the Fifth Circuit decision did not foreclose. Judge Kathleen Cardone, a Bush appointee in El Paso, and Judge David Briones, a Clinton appointee also in El Paso, have both continued granting release in multiple cases based on this constitutional rationale. A Justice Department official, speaking anonymously, characterized these rulings as coming from rogue judges making results-oriented decisions. 27. Meanwhile, a comprehensive analysis by GovFacts found that 373 federal judges have rejected the administration's detention policy while only 28 have sided with it, yet ICE continues enforcing the policy nationwide due to the hierarchical structure of the federal judiciary where circuit court decisions override district court rulings within their geographic boundaries. 28. The detention policy has had dramatic operational impacts. Daily ICE arrests in Texas jumped from an average of 85 per day during the final 18 months of the Biden administration to 176 per day in the first 6 months under Trump. ICE has engaged in high-profile street raids, often accompanied by state troopers and local police, targeting particular areas and businesses. The enforcement has also turned deadly, with an ICE agent fatally shooting Renee Nicole Good, a 37-year-old Minneapolis resident, on January 7, 2026, when she attempted to drive away during an arrest attempt. 2 days later, a Border Patrol agent shot and wounded 2 Venezuelans during a vehicle stop in Portland, Oregon. 29. Defense attorneys and immigration law clinics report being overwhelmed by the historic caseload. Daniel Caudello, director of the Immigration Law Clinic at Texas Tech University School of Law and a recently departed immigration judge, stated, "I don't recall a time that anything like this has ever happened." The legal battles are likely headed to the Supreme Court, as appeals of habeas rulings have been filed in 9 of the 12 regional appeals courts. 24. Data privacy and tech law, new battles and lawsuits. Location data has emerged as the privacy battleground of 2026, with regulators at both federal and state levels intensifying enforcement against data brokers and technology companies. The FTC continued its aggressive enforcement campaign, having issued orders against location data brokers MobileWalla and Gravy Analytics, along with its subsidiary Vintel, in December 2024, following similar actions against Xmode and InMarket earlier that year. These cases establish that selling precise geolocation data revealing visits to sensitive locations such as reproductive health clinics, places of worship, and political gatherings constitutes an unfair practice under Section 5 of the FTC Act, even with user consent. The Gravy Analytics case revealed particularly troubling practices. The company allegedly obtained precise location data from third-party suppliers to track consumers' visits to sensitive locations, then categorized consumers into audience segments based on sensitive inferences derived from their location data, such as medical conditions, political affiliations, and religious beliefs, before selling these segments to third parties including government clients. MobileWalla allegedly collected precise location data from real-time bidding exchanges for purposes beyond ad bidding, using it to geofence sensitive locations and transfer data from apps like Grindr and Jacked to government clients without adequately verifying supplier consent. 24. The FTC orders impose unprecedented requirements including supplier assessment programs mandating companies to review third-party data sources for proper consent mechanisms. 25. At the state level, California Attorney General Rob Bonta launched an ongoing investigative sweep on March 10, 2025, into mobile app providers, advertising networks, and data brokers for potential CCPA violations related to geolocation data. The AG specifically targeted 3 areas: businesses selling or sharing geolocation information after receiving opt-out requests without reauthorization, failure to wait 12 months before asking consumers to opt back in, and mobile apps lacking proper links or settings for location data opt-outs. The California legislature introduced the California Location Privacy Act, AB 1355, in February 2025, which would dramatically expand location data protections beyond precise geolocation to encompass IP addresses, GPS coordinates, cellular tower location information, and data captured by automatic license plate readers and facial recognition technology. The bill would prohibit covered entities from collecting, using, or retaining such information except as necessary to provide requested goods or services, and only with express prior consumer consent. 26. At least 6 states without comprehensive privacy laws have introduced bills banning the sale of precise geolocation data, following Maryland's pioneering ban that took effect in 2024 and Oregon's law effective January 1, 2026. Virginia's Senate passed a bill in February 2026 prohibiting the sale of precise geolocation data, now moving to the House of Delegates. Consumer Reports unveiled model legislation on data location privacy calling for stricter data retention limits and a consumer private right of action for violations. 27. The privacy enforcement trend reflects bipartisan concern at the FTC, with Republican Commissioner Melissa Holyoke and Democratic Commissioner Alvaro Bedoya both supporting the location data cases while articulating different emphases. Commissioner Holyoke cautioned against overly limiting location data use across all contexts, while Commissioner Bedoya focused on aligning commercial practices with Fourth Amendment protections, especially closing law enforcement's ability to purchase commercial location datasets. 28. AI and the legal profession, ethics, discipline, and innovation. The legal profession is grappling with artificial intelligence's rapid integration, facing disciplinary actions for AI-generated errors while simultaneously developing comprehensive ethical frameworks. On February 26, 2026, a California State Bar Court judge approved a disciplinary agreement with attorney Amir Mustafavi that includes a state 1-year license suspension, required ethics school attendance, and mandated coursework on the risks and benefits of the use of AI tools in legal work. Mustafavi's briefs contained AI-generated fake quotes, representing one of hundreds of cases nationwide where attorneys have filed court documents containing hallucinated citations, quotes, and legal authorities. 24. California prosecutors have also faced scrutiny for AI errors. The Nevada County District Attorney's Office admitted in late 2025 to using artificial intelligence in preparing a filing that resulted in an inaccurate citation. In the case of Kyle K. Joller, defense lawyers identified what they described as typical generative AI errors in multiple prosecution filings, including non-existent quotations and misinterpreted court rulings. K. Joller's attorneys filed a petition with the California Supreme Court arguing that prosecutors' reliance on inaccurate legal authority can violate ethical rules, and represents an existential threat to the due process rights of criminal defendants and the legitimacy of the courts. A group of 22 scholars, lawyers, and criminal justice advocates filed a supporting brief. 25. In response to these incidents, California is leading the nation in formalizing AI ethics rules. On March 13, 2026, the State Bar's Standing Committee on Professional Responsibility and Conduct approved proposed amendments to 6 ethics rules, opening a 45-day public comment period that closed May 4, 2026. Rather than creating a standalone AI rule, California wove AI-specific obligations into existing rules on competence, client communication, confidentiality, candor toward tribunals, and supervision of lawyers and staff. The core principle: lawyers must independently review, verify, and exercise professional judgment regarding any output generated by the technology that is used in connection with representing a client. The proposed competence rule requires lawyers to stay current on AI technology and verify all AI-generated outputs. The client communication rule mandates disclosure when AI use presents significant risk or materially affects the scope, cost, manner, or decision-making process of representation. The confidentiality rule addresses the common practice of entering client data into AI platforms without assessing risks of unauthorized access, retention, or use. The candor rule requires lawyers to verify the accuracy and existence of all cited authorities before filing, including any generated or assisted by AI. Managing lawyers must establish internal AI use policies, and the supervision obligations for non-lawyer assistants now extend to AI use in delivering legal services. This rulemaking was initiated by the California Supreme Court itself, which in August 2025 directed the bar to consider whether principles from its November 2023 practical guidance should be incorporated into formal rules, including guidance on agentic AI tools that can plan and execute tasks with minimal human intervention. 26. The California Senate passed SB 574 on January 30, 2026, which would transform bar guidance into enforceable statutory requirements. The bill prohibits attorneys from entering confidential or non-public information into public AI systems, requires verification and correction of AI-generated content, mandates removal of biased, offensive, or harmful AI output, and requires attorneys to personally read and verify any citations in documents filed with courts. The bill now proceeds to Assembly committees for hearings and a potential vote before the August 2026 adjournment. 27. International law and human rights, global legal fault lines. The International Criminal Court faced an existential crisis in 2025 to 2026 as the United States imposed unprecedented sanctions on ICC officials while simultaneously the court achieved a landmark prosecution of a sitting head of state. On February 6, 2025, President Trump issued Executive Order 14,203 authorizing asset freezes, travel bans, and restrictions on U.S. company services for ICC officials involved in investigating U.S. or Israeli nationals. 24. The order declared that any effort by the ICC to investigate, arrest, detain, or prosecute protected persons constitutes an unusual and extraordinary threat to the national security and foreign policy of the United States. 25. Since issuing the order, the administration has sanctioned at least 11 ICC officials, including 9 judges and the chief prosecutor. 24. UN experts condemned the sanctions as an attack on global rule of law that strikes at the very heart of the international criminal justice system. The experts stated that, by sanctioning the ICC, the U.S. president is gravely undermining the "never again" legacy of Nuremberg, a cornerstone of evolving international criminal law since 1945. 25. The sanctions originated from ICC arrest warrants issued for Israeli Prime Minister Benjamin Netanyahu and former Defense Minister Yoav Gallant for alleged war crimes in Gaza. 26. The U.S. position created a stark inconsistency with its earlier support for ICC arrest warrants against Russian President Vladimir Putin and Children's Rights Commissioner Maria Lvova-Belova in March 2023 for alleged crimes in Ukraine. Senator Lindsey Graham, who praised the Putin warrants as an important step for a world order based on the rule of law, became one of the ICC's most outspoken critics after the Netanyahu warrants. 27. On November 11, 2025, UN General Assembly President Annalena Baerbock warned that coercion and sanctions against the ICC are assaults on the very principles of international law itself. ICC President Judge Tomoko Akane told the Assembly that when judges are pressured, threatened, or undermined, the credibility of international law itself is weakened. A resolution presented at the meeting condemned any threats, attacks, or interference against the court, its personnel or those cooperating with it. 26. Despite these attacks, the ICC achieved a significant milestone when pre-trial Chamber I confirmed all charges against former Philippine President Rodrigo Duterte and committed him to trial for crimes against humanity. The arrest and transfer of Duterte reaffirmed the court's relevance in ensuring accountability for serious crimes. The European Union has been criticized for its tepid response to the U.S. sanctions. While most EU member states condemned the sanctions in national and joint statements, the EU as a whole has not issued an official statement, contrasting sharply with its clear positions following similar sanctions by the first Trump administration in 2020. A coalition of 58 non-governmental groups called on the EU to defend the ICC, warning that attacks on the court could undermine justice for victims worldwide. 28. Meanwhile, Amnesty International documented that the Allied Democratic Forces, ADF, an armed group in Eastern Democratic Republic of Congo, committed numerous war crimes and crimes against humanity, including shootings of civilians, abductions, sexual violence against women and girls, and recruitment of children. Amnesty International Secretary General Agnes Callamard called for intensified efforts to protect civilians and bring perpetrators to justice. 29. Human Rights Watch reported that Israel's cabinet approved a $334 million plan to transfer thousands more Israeli civilians into the occupied Syrian Golan Heights, describing it as a clear statement of intent to commit war crimes. 30. Climate and environmental law, legal clashes over emissions and accountability. Climate litigation continued to evolve in 2026 as municipalities, states, and advocacy groups pursued multiple legal strategies to hold corporations and governments accountable for climate change impacts. The legal landscape remains fragmented, with significant battles over jurisdictional issues, procedural barriers, and the substantive reach of various legal theories. Several cities and states have filed climate accountability lawsuits against major fossil fuel companies, drawing comparisons to tobacco litigation of the 1990s. These cases typically allege that energy companies knew about climate change risks for decades but engaged in campaigns to deceive the public and delay regulatory action. The lawsuits seek damages for climate adaptation costs, public nuisance abatement, and consumer protection violations. Defendants have aggressively fought to remove these cases from state courts to federal courts, where they hope for more favorable treatment. Some state legislatures, responding to pressure from industry groups, have enacted laws creating shields against climate-related lawsuits or limiting the ability of municipalities to pursue such claims without state authorization. These legislative efforts have sparked their own legal battles over constitutional issues including municipal authority, preemption doctrines, and separation of powers. At the federal level, the Department of Justice has been involved in litigation concerning state climate policies. The Supreme Court's role in climate law has been significant, with previous decisions establishing or limiting the EPA's regulatory authority under the Clean Air Act. Environmental advocates continue to push for expanded interpretation of existing environmental statutes while industry groups seek narrower readings. The Securities and Exchange Commission's proposed climate disclosure rules have faced intense scrutiny and legal challenges. The rules would require public companies to disclose climate-related risks, greenhouse gas emissions, and climate targets. Business groups have challenged the rules on grounds that the SEC lacks statutory authority and that the requirements are unduly burdensome. The outcome of these challenges will significantly impact corporate climate reporting and accountability. State attorneys general remain divided on climate issues, with some leading aggressive enforcement actions while others join industry challenges to federal climate policies. This split reflects broader partisan and regional divisions over climate policy and energy development priorities. Corporate and financial law enforcement, insider trading and SEC settlements. Corporate enforcement actions in 2026 have revealed sophisticated insider trading schemes while the SEC continues its aggressive pursuit of securities violations across multiple sectors. The most significant development involved an alleged insider trading ring that included attorneys from major law firms, marking a troubling intersection of legal privilege and securities fraud. Law enforcement authorities have charged multiple individuals in what prosecutors describe as a complex scheme involving the misuse of confidential client information obtained through large law firm representations. The case has sent shockwaves through big law, prompting firms to review their information barriers and compliance protocols. Elon Musk reached a settlement with the SEC in 2026 addressing long-standing disputes over social media disclosures and trading activity. The settlement includes financial penalties and enhanced disclosure requirements, though details remain subject to confidentiality provisions. The resolution ends years of contentious litigation between Musk and securities regulators over his public statements and their market impact. The SEC has also announced multiple settlements with companies and individuals for beneficial ownership reporting violations. These cases involve failures to timely disclose significant stock acquisitions or dispositions as required under Section 13(d) and 16(a) of the Securities Exchange Act. The enforcement actions signal the SEC's continued focus on market transparency and timely disclosure of material information to investors. Broker-dealer enforcement remains a priority, with the SEC imposing substantial fines on firms for supervisory failures, best execution violations, and inadequate compliance systems. These cases emphasize the heightened expectations for internal controls and the personal accountability of compliance officers and senior management. The Department of Justice has updated its corporate compliance policies, providing clearer guidance on factors considered when evaluating whether to bring criminal charges against corporations. The updated policy emphasizes individual accountability, the effectiveness of compliance programs, and cooperation with government investigations. Companies demonstrating robust compliance efforts and meaningful self-disclosure may receive more favorable treatment. Bank fraud indictments have targeted individuals and institutions involved in loan fraud, PPP fraud from pandemic-era programs, and cryptocurrency-related schemes. Federal prosecutors have prioritized cases involving technology-enabled fraud and cross-border financial crimes, often coordinating with international law enforcement agencies. The SEC's whistleblower program continues to generate significant results, with multiple large awards announced in 2026. The program has paid billions to individuals who provide original information, leading to successful enforcement actions. The awards serve both to compensate whistleblowers and incentivize reporting of securities violations. Consumer and competition law, antitrust suits and right to repair. Consumer protection and antitrust enforcement agencies escalated their efforts in 2026, pursuing cases that could reshape competitive dynamics across multiple industries. The right to repair movement scored a significant legal victory with a class action lawsuit against Porsche alleging anti-competitive practices in restricting independent repair options for vehicle owners. The lawsuit claims that Porsche maintains an illegal monopoly over repair services by limiting access to diagnostic tools, proprietary software, and replacement parts necessary for vehicle maintenance. Plaintiffs argue these restrictions force consumers to use authorized dealers at inflated prices while preventing independent mechanics from competing. The case could have broad implications for automotive manufacturers' control over repair markets. Trademark litigation continued to generate high-stakes disputes. Pepperdine University filed a trademark infringement lawsuit against Netflix over alleged unauthorized use of university marks or imagery in streaming content. The case raises questions about intellectual property rights, fair use defenses, and the balance between creative expression and trademark protection. PBS initiated a copyright lawsuit addressing the unauthorized reproduction and distribution of its educational and entertainment content. The case involves digital streaming platforms and raises issues about content licensing, fair use, and the scope of copyright protections in the digital age. The music industry saw multiple royalty disputes reach the courts. T.I. filed a lawsuit concerning his music catalog rights and revenue distribution. Enrique Iglesias initiated legal action over royalty calculations and contractual interpretations affecting his recorded works. These cases highlight ongoing tensions in the music industry over legacy contracts, streaming revenue allocation, and artists' rights to control and benefit from their creative output. A gambling app faced a class action lawsuit alleging deceptive practices, undisclosed odds, and inadequate consumer protections. The litigation examines whether certain mobile gaming apps constitute illegal gambling, what disclosures are required, and how consumer protection laws apply to digital gaming platforms. State attorneys general have joined investigations into the gambling app industry, particularly concerning youth access and addiction risks. The FTC took enforcement action against Valvoline's proposed merger, challenging the transaction on grounds that it would substantially lessen competition in automotive maintenance services. The case involves detailed market definition analysis, competitive effects modeling, and examination of potential efficiencies. The FTC's aggressive stance on vertical and horizontal mergers continues, with the agency applying updated merger guidelines that emphasize structural presumptions and broader definitions of anti-competitive harm. Companies considering significant transactions face intensified scrutiny and longer review timelines. Entertainment and media law, settlements, free speech, and property rights. Entertainment and media law developments in 2026 have addressed fundamental tensions between privacy rights, property interests, and creative expression, while also resolving high-profile disputes over contractual obligations and intellectual property. Celebrity privacy and settlement. Blake Lively reached a settlement in 2026 addressing legal disputes related to privacy, publicity rights, or contractual matters connected to her entertainment career. While terms remain confidential under the settlement agreement, the resolution ends litigation that had attracted significant media attention. The case involved complex issues of celebrity rights, media coverage, and personal privacy in the digital age. Property rights and historic preservation. A landmark property rights case emerged involving Marilyn Monroe's former Los Angeles home, with heirs or preservation advocates filing a regulatory takings lawsuit against the city. The litigation challenges a city decision to designate the property as a historic landmark or impose preservation requirements that allegedly deprive owners of economically viable use. The case raises constitutional questions about regulatory takings under the Fifth Amendment, the scope of historic preservation authority, and the balance between cultural heritage protection and private property rights. Trademark and branding disputes. The Pepperdine Netflix trademark case, also relevant to consumer law, addresses whether streaming content inappropriately uses university branding or creates misleading associations. The litigation explores the boundaries of artistic expression versus commercial exploitation of institutional identity. Taylor Swift faced a trademark dispute concerning the protection of phrases, song lyrics, or branding elements associated with her music and public persona. Trademark law in entertainment involves navigating the intersection of commercial branding, artistic expression, and fan culture. The case examines what elements of an artist's creative output can receive trademark protection. NDA enforcement and First Amendment issues. Howard Stern filed a lawsuit addressing NDA enforcement and contractual restrictions on speech. The case involves complex First Amendment considerations, the enforceability of confidentiality agreements, and the balance between contractual obligations and public interest disclosures. The litigation could establish important precedents for employment agreements in the entertainment industry. RICO and music industry litigation. Drake initiated a RICO lawsuit alleging an organized scheme involving fraud, copyright infringement, or contractual interference. RICO claims in entertainment disputes are relatively rare and signal allegations of systematic wrongdoing beyond ordinary business disputes. The case involves detailed fact patterns concerning the music industry's business practices. Contract litigation in television. Mike Rowe, the television host, is involved in contract litigation addressing compensation, intellectual property ownership, or breach of agreement claims related to his television work. The case involves standard entertainment industry issues of creative control, revenue participation, and contractual interpretation. These entertainment law cases collectively illustrate the evolving legal landscape for celebrities, content creators, and media companies navigating issues of privacy, property rights, intellectual property, and contractual obligations in an increasingly digital and globalized entertainment industry. Table of Contents. Disclaimer, Section 2. Supreme Court ruling Royals election law and courts independence. Section 3 Louisiana v. Calais decision weakens Voting Rights Act. Justice clashes over expedited judgment. Louisiana primary delays. Partisan redistricting implications. Immigration law crackdown and court battles. Section 4 mass detention policies challenged. 18,000 habeas corpus petitions filed. Fifth Circuit ruling on mandatory detention. Federal judge workarounds. ICE operational changes. Data privacy and tech law. Section 5 FTC enforcement on location data brokers. California AG investigative sweep. State privacy law proliferation. Facial recognition technology regulation. Bipartisan privacy concerns. AI and the legal profession. Section 6 Attorney discipline for AI-generated errors. California prosecutor AI mistakes. State bar ethics rule amendments. SB 574 legislative requirements. Agentic AI considerations. International law and human rights. Section 7 U.S. sanctions against ICC officials. Duterte prosecution milestone. War crimes accountability challenges. EU response to ICC attacks. DRC and Syria human rights violations. Climate and environmental law. Section 8 Municipal climate accountability lawsuits. State anti-climate lawsuit shields. Supreme Court's regulatory authority decisions. SEC climate disclosure rules. DOJ environmental enforcement. Corporate and financial law enforcement. Section 9 Big Law insider trading allegations. Elon Musk SEC settlement. Beneficial ownership violations. Broker-dealer enforcement. DOJ corporate compliance policy. Whistleblower awards. Consumer and competition law. Section 10 Porsche right to repair lawsuit. Trademark disputes. Pepperdine Netflix. PBS. Music royalty litigation. T.I. Enrique Iglesias. Gambling app class action. FTC Valvoline merger challenge. Entertainment and media law. Section 11 Blake Lively settlement. Marilyn Monroe house takings case. Howard Stern NDA lawsuit. Drake RICO suit. Taylor Swift trademark case. Micro contract dispute. References. 1 Louisiana map. Abortion sends Supreme Court emergency docket roaring back. 2 Supreme Court weakens Voting Rights Act in major redistricting case, voiding Louisiana's congressional map. 3 Monday's Supreme Court voting case order and its many problems. 4 Supreme Court clears way for Louisiana to redistrict ahead, Politico. 5 In major Voting Rights Act case, Supreme Court strikes down. 6 Supreme Court rules on Voting Rights Act, striking down Louisiana map. 7 Supreme Court strikes Louisiana map, reshapes Voting Rights Act. 824-109 Louisiana v. Calais, April 29, 2026, Supreme Court of the United 9 Texas Court District leads U.S. in immigrants challenging legality of 10 Trump 2.0's expansion of mandatory detention, policy shifts, judicial 11 373 judges rejected this detention policy. Why ICE can still enforce it. 12 judges may have found a way to bypass Fifth Circuit ruling, Politico. 13 The Great Writ under siege, habeas corpus in the age of mass detention. 14 As immigrant arrests rise, here's what to know about ICE operations in 15 Location, FTC continues data broker, Mundek. 16 Location, FTC continues data broker enforcement. 17 Privacy regulators target the location data industry. 18 Protecting geolocation data emerges as state privacy priority. 19 A view from DC, geolocation enforcement trends include broad lessons. 20 Professional probation recommended for attorney whose briefs had AI. 21 California prosecutors' AI mistakes raise concerns about due process. 22 California bar proposes rule requiring lawyers to verify every AI. 23 California Senate passes SB 574 to regulate lawyers' use of AI, Clio. 24 U.S. sanctions against the International Criminal Court, Harvard Law. 25 United States, UN experts condemn sanctions against the ICC. 26 International Criminal Court, sanctions threaten global fight, UN News. 27 Victims of international crimes need justice and the ICC. 28 EU should defend the ICC, International Criminal Court under attack by 29 Rights group claims armed group in DRC committed war crimes and crimes against humanity. 30 Israel bankrolls war crimes in occupied Syrian Golan.